Hello, and welcome to This Explainer. I'm Michelle. If you're an adult child helping an aging parent right now, or maybe you're a homeowner over 50 exploring your options, just the thought of navigating Medicaid alongside a home sale can feel incredibly overwhelming. It's a lot to take in. So let's alleviate some of that anxiety today. We're going to break down exactly how Medicaid estate recovery works in plain English so you can make confident, informed decisions for your family without all the stress.
Okay, let's dive right in and address the absolute biggest fear I hear from families. Does selling a home automatically trigger Medicaid recovery? Well, the short answer is no, it doesn't. I want to reassure you right off the bat that the simple act of selling a house while your parent is still living just doesn't work the way so many people fear it does.
To understand exactly why that is, let's look at this first section on common Medicaid confusion. You see, families often conflate two very different concepts, which causes a whole lot of unnecessary worry, and unfortunately can actually lead to delayed decisions when time really is of the essence. Let's look at the actual definition of estate recovery. Yes, state Medicaid programs are required to recover certain benefits, things like nursing facility services and related hospital costs, for individuals 55 and older. But here is the absolutely crucial, comforting point. This recovery process happens only after a person has passed away, and it happens exclusively through the probate process. It literally does not happen while your loved one is still living. This brings us to our next section, estate recovery versus ongoing eligibility. Gently guiding ourselves to understand the vital difference between what happens after a loved one passes versus what happens while they are still receiving care, well, it truly changes everything. Think of it like two completely different rule books. On one side, we have estate recovery, which, again, only begins after a loved one passes away and their estate enters probate. On the other side, we have Medicaid eligibility. This involves strict asset limits while your loved one is alive. Mixing these two concepts up is exactly what leads to poor timing and those unexpected, stressful financial gaps. So let's talk about those asset limits for a moment. Medicaid enforces very strict rules for ongoing eligibility. For an individual, that limit is often around just $2,000. To put that into perspective, you really can't have much cash on hand at all if you want to keep receiving those benefits. So, what actually happens if you sell the house? Imagine accidentally disqualifying your mother from her care simply because you were trying to help her downsize. You see, selling a parent's home turns it into an immediate cash asset. If that parent is currently receiving Medicaid, a sudden influx of cash from a home sale could instantly push them way over that $2,000 eligibility limit. The result? A temporary loss of their care benefits until those funds are properly spent down. This is why selling while a parent is alive is an entirely different conversation than estate recovery. Now let's transition to some very comforting news. In this section on Illinois rules and protections, we're going to look at specific guidelines that can offer your family a tremendous amount of peace of mind. For those of you in Illinois, the state actually has some wonderful built-in protections. For deaths that occur on or after July 1st of 2022, Illinois entirely exempts the first $25,000 of estate value from recovery. So, just to do the math, if an estate totals $40,000, the state can only pursue the amount above that $25,000 threshold. The rest is completely protected. And, even more reassuringly, Illinois actually stopped filing new liens on real estate as a recovery method entirely, effective June 2nd, 2022. Now, while older liens remain enforceable, the state operates as a probate-only state. This simply means they no longer file new liens directly against homes, and they can only reach assets that actually pass through probate court. That's a huge relief for many families. There are also some fantastic automatic exemptions that protect a really meaningful share of families without you ever needing to file for an exception. For instance, Illinois will not pursue estate recovery if there is a surviving spouse living in the home, a surviving child under 21, or a child of any age with a permanent disability or blindness. And as we just saw, if the estate is $25,000 or less, the whole shebang is completely exempt. There's another vital protection worth keeping in mind. If one spouse needs long-term care but the other continues living independently, a portion of their combined resources is protected. This ensures the healthy spouse isn't forced into poverty. Looking ahead to 2026, that protected amount reaches up to $162,660.
But you might be wondering, what if your family doesn't meet those automatic exemptions? Well, that leads us right into our section on hardship waivers and exceptions. Even without those automatic protections, compassionate options still exist.
In Illinois, you might qualify for a hardship waiver if the home served as a family business, like a working farm, for instance, for at least a year, or if recovering the estate would push the heirs themselves onto public assistance. Understanding these waivers right now gives you the breathing room to gather proof calmly, rather than scrambling under deadline pressure during a crisis.
So, how do you actually prepare for all this? Let's pivot to our section on practical steps for families. These are totally low-pressure things you can do right now to protect your loved ones.
Here is a simple, concrete checklist to get you started. First, take a moment to note exactly who currently lives in the home, their ages, and any disability status. Next, confirm whether your parent has already applied for or is currently receiving long-term care Medicaid. Finally, just gather up your property and equity documents. Having these in a nice, neat folder before you meet with any professionals will save you so much time, money, and stress later on.
As a seniors real estate specialist, I always remind families of this golden rule. Coordinating both sides from the start tends to prevent costly surprises later. Please consult a real estate professional and an elder law attorney early on in the process. Treating the home sale and Medicaid questions as totally separate conversations rarely works well, simply because they are so deeply intertwined.
Now, because every homeowner's situation is beautifully unique, please keep in mind that this explainer is strictly for educational purposes. I always encourage you to sit down with a qualified CPA, tax advisor, or estate attorney before making any big decisions regarding your home or your family's finances. Which brings us to our final thought. The rules around Medicaid in your home really don't have to be a source of fear. They just require a bit of mindful planning. So, I'll leave you with this question. Are you ready to explore your family's options with confidence and clarity? What is one small step you can take today to ensure your family's legacy is protected for tomorrow? Thank you so much for joining me to talk through this today. Take care, and feel free to reach out to our community if you ever need guidance.